Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Well gang, Donna Adelson's trial is quickly approaching next month, and there are likely going to be some really epic evidentiary fights in that case. Now most of those are going to occur outside the presence of the jury and outside the streaming cameras. They're probably going to be conducted in chambers. In fact, I'm sure there will be motions in limine and cross motions and all kinds of things. I'm sure the defense will work very hard to keep out as much information as possible. But at the end of the day, I don't think there's really much doubt as to how this is going to come out. But it'll be interesting from the standpoint of watching the trial tactics, watching the cross-examinations, as to what it is each of these parties are going to try to get across to the jury. Now, one of the crimes that Donna is alleged to have committed in her case is conspiracy to commit murder. And conspiracy is an interesting sort of topic. Conspiracy has long been a part of the criminal law. Under the common law, conspiracy was usually described as an agreement between two or more persons to commit an unlawful act or accomplish an unlawful end by unlawful means. While that's simple in definition, it is still perhaps the most amorphous area in the criminal law. In some jurisdictions, the definition of conspiracy is the agreement between two or more people to commit a crime and at least one act in furtherance of that objective. So John and Carl could get together and decide to rob the local PNC bank and agree to do that. And that agreement alone would not be a crime. But the moment that John steals a car for the getaway, or that Carl steals a gun to use in the robbery, that sets into motion the conspiracy because you have an act in furtherance. And now you have both John and Carl on the hook for the crime. Now, if they don't commit the crime, but they get caught for possessing the gun or the stolen car, and they admit during questioning that they did that so that they could rob a bank, well, now you're going to see a conspiracy charge. And I don't think most criminals ever think about that because they think, well, I didn't do that crime, so I'm not going to be guilty of that. No, you're not going to be guilty of the crime of robbery, but you are going to be guilty of the crime of conspiracy to commit robbery. In some other jurisdictions, like Florida, the moment John and Carl agree to commit the robbery, they're on the hook for the criminal act, even if they don't take an act in furtherance of that objective. If they don't carry forth with the plan, then it's unlikely that anyone finds out about their agreement to rob the bank. If they both say, that's a dumb idea, let's not do that, then again, they've still committed the crime, but they are unlikely to be prosecuted for it simply because no one else knows about it but those two. And of course, neither one can, cause problems for the other, because if they cause problems for the other guy will cause problems for them. Conspiracy is a notoriously difficult crime to defend, and it's also somewhat easy to prove. Under Florida Statute 777.04, subparagraph 3, which is the statute that Adelson is charged with and for conspiracy, a person who agrees, conspires, combines, or confederates with another person or persons to commit any offense commits the offense of criminal conspiracy. Under this statute, the idea that they're going to be able to prove the agreement and the conspiracy is not going to be a heavy lift. At trial, the prosecutors are going to have to prove that Donna intended that a murder of Dan Markell would be committed and agreed with Charlie and Katie and maybe even the two thugs or any one of them to commit that act. Now, a conviction for conspiracy under Florida law is punished one offense level below the crime committed. So in Donna's case, murder would be a capital felony, and the conspiracy to commit murder would be a first-degree felony. I think the maximum penalty is 30 years in that case. Now, it's pretty rare for a prosecutor to have direct evidence, direct documentary evidence of a conspiracy, although you do see that from time to time in civil conspiracy cases. People are rarely dumb enough to send an email or a text to their partner in crime and say, hey, how about we revoke the birth certificate of old Jim Bob? And rarely does someone with more than 2 brain cells respond back with, awesome, dude! It's really difficult to get direct evidence of a conspiracy. But you know, what's really amazing to me is, I don't know if any of you have done the same thing, but periodically there are little snippets of episodes of The Sopranos that come up on my YouTube feed. And I'm always watching The Sopranos clips because Tony Tutos likes the guys. You know what I'm saying? At any rate, every one of those, there is one common theme, right? Same thing with all of the Godfather movies, with Goodfellas, with Casino, and pretty much every other movie made about organized crime since the telephone became commonplace. There are still people, having watched those movies, who believe that it is safe to talk about their criminal plans on the telephone. Worse, in many cases, long after the crime has been committed, these same folks who should be saying nothing and should respond with shock and alarm at being approached as a conspirator by an undercover detective, these people continue to talk to themselves and talk to others who are essentially just inviting themselves to be indicted because, as you may recall from the last video that I did about the Adelson case, the undercover cop hits up Donna, they have her phone tapped, and they catch her talking to Charlie, and Charlie's talking to Katie, and they wrap up the whole conspiracy on the basis of those phone calls. Well, those phone calls are not direct evidence of the conspiracy because nobody on those phone calls is saying, hey, remember when we agreed to, revoke Dan's birth certificate? No, they're not doing that. But what they are doing is they're talking about it, and you can determine that they have knowledge, and that's what we call a reasonable inference. The jury will hear those phone calls, and they will reach the reasonable inference that Donna was indeed involved in this. You likewise probably remember from Charlie's trial the ridiculous excuses Charlie made for the phone calls and the payment of money to Katie Magbana. And Katie. I can't say that woman's last name for love nor money. Because they cannot prove a conspiracy directly, the state's going to use circumstantial evidence of the conspiracy, the phone calls, the facts that were introduced at trial in Charlie's case, and in this case, the fact that the conspirators were talking about their interactions with the undercover to create the inference that they had conspired with each other. That is going to be fairly powerful evidence for the jury in this case. In some respects, since Katie and Charlie and the 2 idiots who pulled the trigger in this case have all been convicted, the proof of the crime, the proof of the actual murder, is probably not, strictly speaking, necessary. It's probably done by collateral estoppel. But of course, Katie and Charlie both have appeals pending, so they are not completely free of any chance that their convictions might be reversed. So as a result, the state is going to have to put on all of the evidence to get the jury to conclude that Donna and Charlie both had a hand in what happened in this case. While there are defenses to the crime of conspiracy, including these from subparagraph 5 of the statute, the statute says it is a defense to a charge of criminal contempt, criminal solicitation, or criminal conspiracy that under the circumstances manifesting a complete and voluntary renunciation of his or her criminal purpose, the defendant abandoned his or her attempt to commit the offense or otherwise prevented its commission. Well, we know that didn't happen. Donna didn't abandon anything. The offense was committed, and there was no call from Donna to Charlie trying to call it off, at least none that's been reported. B, after soliciting another person to commit the offense, persuaded such other person not to do so, or otherwise prevented the commission of the offense. Again, we know this didn't happen. Donna worked with Charlie to have Katie do the actual solicitation. So there's not really any defense there. C, after conspiring with one or more persons to commit an offense, persuaded such persons not to do so, or otherwise prevented the commission of the offense. And we all know that didn't happen either. Now, this is not a death penalty case. And in some respects, I would imagine that the Markell family might wish that it was. But I wanted to share a little bit about trial strategies when it comes to these kind of cases. As I've talked about on this channel before, my first job in the law was as a law clerk to the Chief Justice of the Missouri Supreme Court. One day we got around to talking about the death penalty cases. The death penalty cases were handled very differently in oral argument than were regular civil appeals. In civil appeals, litigants would get between 15 and 20 minutes to present their case, and that would be it. But you would often find in a death penalty case that the public defender who's doing the defense or doing the argument in front of the Supreme Court, he might very well get 30 minutes or 45 minutes to present his reasons for why the case ought to be reversed. And of course, the state got equal time in that situation. But once the case was presented and it went back to be decided, if indeed the case was going to be affirmed, well, that's when people like me who were clerks were tasked with going through the record and finding the really awful parts of that particular crime. And my boss explained that writing a death penalty opinion was a little bit like writing a gothic horror novel. You walk the reader up to the front porch and describe the river of blood flowing down the steps. Now that's metaphorical, obviously, because that rarely happens. But the idea is you make it very clear through the written word exactly what happened to the victims in that case. And of course, courts can only do that when the prosecutors provide the evidence necessary for that kind of graphic description. And Adelson's trial will have that kind of graphic evidence and information. The jury is going to see crime scene photos, and they'll hear testimony from the shooters and from Magbanua. And the prosecutors could potentially put on other testimony. It will be a trial similar in scope to Charlie's, and the proof will be pretty much the same as what you got in Charlie's, but of course some of it will be tailored to Donna's cooperation and participation in the actual crime. At the end of the day, there really won't be much of a question as to whether there was a conspiracy or whether there was an unlawful killing. Still, there could be moments of high drama, and we could learn a lot of new information. The jail phone calls are going to come in, the attempt to flee will come in, and of course all of the other things, as I said, that came in Charlie's case are going to come in here. The prosecutors have put Charlie on the witness list. Now whether he will come in and testify, I don't know. He can certainly assert the Fifth Amendment because by asserting the Fifth Amendment, he still has an appeal pending. He doesn't want to jeopardize his appeal. Usually the statements of co-conspirators face some hurdles in getting in front of a jury. But we'll have to see whether or not that's actually something that Donna needs to worry about. I don't know whether Charlie is particularly upset with his mom or not, but generally speaking, blood is thicker than water, and I would imagine that they'll probably hang together as opposed to hanging separately. I'm looking forward to the trial. I don't know about you. I plan on covering it here on the channel. If during the course of the trial you find a particularly interesting part of the testimony that you'd like me to explain or go into, you can drop me an email at this address, and I will be happy to do that. Make sure you put in the header, Adelson trial, video request, something like that, so I know what it is you're asking me to do. So that's what I have for you today. Thank you so much for watching. If you have the opportunity today, do something nice for someone. And if you have questions about this video, drop them in the comments down below or email them as I mentioned earlier. Then, when you've had an opportunity to do something nice for someone, and I hope you do, I know a lot of people tell me every other day I get an email or a comment that says, you know, I heard you say that and this is what I did. I really love to see that because I do think we make the world a better place when we practice kindness. Thank you so much for watching. Have a terrific day. Come on back down here and join me at the beach tomorrow. We'll talk about something else. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.